They spent their efforts having a ballistics expert come in, show you a very nice PowerPoint presentation, which in the end proved only that the shell casings possibly, there's that word again, possibly came from an aftermarket slide for a firearm frame that could possibly have been compatible with the Glock 43.
Fence is wrong.
Are you sure?
I'm positive.
This is your opinion?
It's a fact.
I find it hard to believe that this kind of information could be ascertained simply by looking at a picture.
Would you like me to explain?
I would love to hear this.
So would I.
As the jury is getting ready for the ASAP Rocky case deliberation, we are met with ASAP and Rihanna's kids in the courtroom today. What we really want to highlight is Attorney Lewin for the state. Where do we start with this one? Not only did he object over 10 times during the closing argument, the judge, reasonably pissed off, put him in his place. Let's talk about reasonable doubt. It's a big thing that comes into the defense's argument. Reasonable doubt is defined as the doubt that prevents one from being firmly convicted of a defendant's guilt or the belief that there is a real possibility that a defendant is not guilty.
Anything inconsistent with what Lou said, you're going to hear that thing.
Your Honor, we found out about it that day. It's improper.
There are no speaking objections. There are no speaking objections. I told you that. You will have an opportunity in your rebuttal argument.
Objection, improper argument.
Overruled.
Because he says it loudly.
Objection, improper argument.
That is sustained. Don't do that, Mr. Tank.
Anyway, you were hurt. You know, they knew about the 11 prosecution before this trial started. They knew before this trial started, he said that the prop gun came from a music video that could have looked like, and they could have put prop houses, the music video, whatever else. They could have done it too. But they didn't say, oh, we didn't do it. Again, you have absolutely no burden to do anything. We did provide live witness testimony. You cross-examined. It wasn't surprising them. They didn't want it to be true because they knew what they were going to find. That's why you didn't hear anything.
That's improper argument.
Reveille's words and actions on November 6, 2021 show you it wasn't the real time. His words and actions show you. All the prosecution's objective evidence in this case, everything that doesn't come from Reveille shows you this was not real time.
Here we go.
Ms. Lemon never said anything about the lawyers who talked about the defense. The defense has said as follows. We're trying to win at all costs. We only care about winning, not just.
Did I sustain that objection?
No, you did not until 4 times. I asked it, Your Honor. I objected 4 times. Let me continue. We suborned perjury, stated 3 times. I objected each time. We could have called the worst of them all. We could have called Haji. The court knows we found out about him that morning. The court made a finding that their discovery violation was not inadvertent. That means it was intentional. That means it was not accidental. They got up here and just told this jury that they didn't hear from this witness Haji, that we could have called him. The court knows we have a hearing about it. It's been very clear. The court found that they were not honest in what they provided. They were not honest about when they actually turned the information over. And now he's up here and able to argue that. And when I object, basically I'm told it's overruled. I mean, Judge, the problem is the court made these findings. The court said you could not disparage lawyers. Let's be clear. Anything that he had said was true. That we suborn perjury. That we don't care about justice. Those are reportable issues to the state bar. The court knows it's not true. I know you know it's not true, Your Honor. I assume he knows it's not true. And then finally, he has repeatedly misstated the standard of reasonable doubt. There is no standard whatsoever where you can say that each one of these are, quote, reasonable doubts. That is not a correct standard. The standard is.
Jacopina's writing
looking at
everything
all
down.
the evidence in total. Did the people prove the case beyond a reasonable doubt? It is improper to say, if this fact is wrong, that is, quote, a reasonable doubt. You can argue that that evidence is important enough, etc. So they're misstating reasonable doubt, but more than that, Your Honor, they're disobeying the court's order about disparaging other lawyers. I object, the court lets it go. Then
No,
they have-
wait a minute, I don't let it go. If I see or I think that Mr. Tacopina is disparaging you or you are disparaging him, I will put a stop to it.
Judge, I objected.
Stop!
Objected 4 times. You overruled all my objections. You finally sustained an objection. And when the court sustained the objection, I made clear that my issue was the second part of it, which had to do with they were in essence disparaging both of us. Your Honor, I mean, it's
He is telling the judge that the judge is doing a bad job. Don't come at Lou Pickles like that, man. He's ready to retire. Are you serious?
not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on, Kathy, was that said?
Your Honor, we said,
All right.
said 3
If
different
it
times.
was said, then I should have stopped it, but I don't remember if it was said. You have made so far 9 objections, 6
Yes.
were overruled, 2
9.
were sustained.
The problem
So
was,
therefore, what?
the problem was, I believe the first 5 I made were all overruled. The court, Your Honor, I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are.
So you also know, if you know what you're doing, that typically it's frowned upon to interrupt somebody's closing statement. The defense did not interrupt you guys, not one time. You didn't see a single objection from the defense. You literally just looked at this judge and he counted. He said, we have 9. 6 were overruled, 3 were sustained. What are you talking about, Lewin? Oh my God.
I'm not gonna sit here and tell the court that I'm objecting when he didn't say it. He said repeatedly, we suborned perjury. Your Honor, that statement in and of itself is severe misconduct.
All right, can you, in the break, can you say, if that was said, then I'll bring it to the
Lock him up,
attention.
lanyard.
That's an improper statement.
This is what I'm asking. Mr. Tacopina can go after our witness all he wants. He can even misstate the evidence. What he cannot do is he cannot argue, A, why we put a witness up there. He cannot say that we suborned perjury. He cannot say that all we care about is winning. He cannot say that this is supposed to be the pursuit of justice.
Hall monitor.
He doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or he doesn't care. And Your Honor, the court's already found, and the worst of them, and I want the court to instruct, he got out there and argued, why didn't you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Oh
Well,
my God.
will the court do something about it? Will the court instruct that that was improper argument?
Can I respond?
No. Failure to call logical witnesses is permissible. You're gonna have a rebuttal argument. You can address it in your rebuttal argument as to why you didn't call it.
Your Honor,
Exactly. Shut up. Sit down.
I'll sit there. The court knows what happened. We've had many hearings on this, etc. They knew the evidence. They presented it late. They had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. So when he's standing up saying, well, that's not his statement, that was his statement, that's what they had to turn over. So yeah, Your Honor, I can go back and I can go and argue in the court and say, well, it's just both sides are arguing. But Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply with discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Non-inadvertent, Your Honor, means they lied and they intentionally did not give us what
I
they
don't
were
agree with that. That's not, it doesn't mean he lied.
Your Honor, non-inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent.
Oh my-
I'm not going to debate with you whether they were or were not lying. I don't believe.
Y'all can't see it, but Rocky is standing up next to Tacopina at the same time. You could see him standing, like he's actually standing in a different frame.
It was a lie. I want to give the court reporter a break, and we'll take a break until 3. What?
I'll give her, I have to just respond with a few things, what's in the record here. One thing, I don't want to upset, so we can do it.
You're not going to upset me.
No, I'll be quick, I don't want to give her a break, I'm sorry. But there were some things that were said that were just wrong. First of all, they called our witnesses liars in their summation. So I'm calling their witnesses a liar, which he admitted to being, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously, they're saying we came up with this Tottenham story. So they're saying, I object, as they sound sworn, but that's what they're saying, number one. Number two, I can't say that they want to win at all costs. That's an argument. I can't say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that wasn't a statement. I said it's not a sworn statement of 12B, and it's not a recorded statement. I said it's a summary. I'm accurate in describing it. It is a summary. I'm just going through what I said. You know, they disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him when he didn't interrupt you?
You know, and the thing that he said though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. If the jury finds he's incredible on one thing of importance, like the shell casings, that's a reasonable doubt. If they so choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. They can say, no, it's not a reasonable doubt, but I can make that
It's a fair
argument.
comment.
I know.
It's fair.
But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said initially, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lululemon. I said, if Lululemon was inconsistent with Haji, would have heard the tape. I didn't say they could have called Haji. I defied to show you where I said that. I would never have said that. We could have called Haji. He wasn't willing to come. So I never said that. I just simply said what was on the record.
Right.
Anyway.
If it was said, Mr. Lewin can address it tomorrow. If it wasn't said,
It wasn't.
then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find
Wow, y'all, we got it. We got it. They're supposed to be back at 6:15 my time, 3:15 their time. We're going to jump off of the Court TV bandwagon. And guess what? I mean, Court TV caught that. Law and Crime's audio came down. So we weren't able to see what they were saying. You know, it just looked like they were standing up. Here we go. Hold on. It's not right there. It's right here. So I'm gonna hit play. Yep. Law and Crime didn't even play that. So nobody heard it. You guys were here. Shout out to me and Court TV. If y'all could type AV in the chat. We did it over here on this channel. We were able to hear all of that crying. Imagine being in Law and Crime's chat and this is all you see. You don't know what's going on. You just see the head wagging. You just see all of that. Shout out to us, guys. We were able to hear all the shenanigans. Lewin talking about, this is not fair. Oh my God, it's not fair. I'm losing so badly. Look at my lanyard, Judge. How many objections were there? There were 9. And you overruled only 3 of them. I want wins, Judge. I want wins. Give me my wins. It's not fair. It's not fair at all. And meanwhile, Tacopina's just like, if you don't shut the hell up, like if you don't stop, like stop, like just stop. And then look at the judge, look at Lou Pickles. You know, come at Lou Pickles and you know, talk about how he's not doing a good job. And then look, Tacopina's like, I need to say something. Can I please say something? And the judge is like, I'll hear you out. I'll hear you out. Man, oh man. Oh, y'all like my Lewin voice? This is unfair. That's not okay. You know, Judge, I've been doing this for 30 years. Judges are usually much nicer to me. I usually get my way. I get what I want. But I'm not getting that right now, and it's all your fault. It's all your fault. Let us know what you think in the comments section below. See you in the next one. Stay safe out there. Bye.